Welcome to Prediction News Update. My name is Chris Gerlacher, the senior political reporter and industry analyst for Prediction News, where we're covering all the news in the prediction market industry. I've got sports betting appellate lawyer Daniel Wallach here with me today. Dan, how you doing?
Doing great, Chris.
Nice.
Good to be back this week. We had a fun show, good opening episode, and I think we've got a nice routine going, and looking forward to doing a few more of these action-packed episodes today. So thanks for having me back.
Oh, thanks for coming. Well, I know we're going to talk about Brian Quintenz's hearing, but before we get into that, I want to ask you very quickly what you liked and didn't like about New Jersey's opening brief in the appellate case.
Yeah, I mean, as you know, New Jersey lost the lower court decision on a motion for preliminary injunction. Court granted the injunction. New Jersey took an immediate appeal to the Third Circuit U.S. Court of Appeals. So their brief was filed yesterday, their opening brief. It's on an expedited appeal. All briefs are going to be filed, before the end of July, with the decision probably late summer, early fall. The brief was, in short, it was a swap meet, a 50, 60-page brief predominantly devoted to what was meant by the CEA's definition of swap, whether it has a potential financial, commercial, or economic consequence. So I think the brief was heavily devoted to the issue of what is and what is not a swap within the context of the main argument over preemption. What did Congress intend when it created exclusive jurisdiction for the CFTC and gave it authority over swap contracts? And the state devoted a lot of attention to utilizing hypotheticals, showing how absurd and ridiculous Kalshi's proposed definition of swaps was taken to its extreme. I mean, the statutory language is the statutory language, but under the proffered approach of Kalshi, if you and I make a bet as to whether you're going to be late for the Amtrak train, well, that has potential economic consequence to you. And what New Jersey effectively did was use hypotheticals and illustrations to kind of, showcase what they view as the absurdity of the definition of swaps taken to an extreme.
Okay. Any weaknesses in their argument, or are we waiting for Kalshi's response to see what holds up on the state side and what doesn't?
Well, a couple of things. One other area that I liked is that New Jersey highlighted the meaning of exclusive jurisdiction. I mean, the courts so far have interpreted Section 2 of the CEA's exclusive jurisdiction grant to the CFTC as basically total exclusive jurisdiction as between all federal and state governmental agencies. Both Judge Abelson in the Maryland case and New Jersey yesterday seem to more narrowly interpret the grant of exclusive jurisdiction as meaning only as between federal agencies, where I guess there was a turf war between the CFTC and the Securities Exchange Commission, and that grant of exclusive jurisdiction was intended to keep these different federal agencies in their own lanes rather than divest state governments over authority regarding, sports wagering or other kinds of state gambling laws. So that's going to be a very key issue that was raised in the Maryland hearing 2 weeks ago and has now been injected into the Third Circuit appeal. What I didn't like about New Jersey's brief, they didn't touch upon any of the preliminary injunction elements. They focused too heavily on the preemption issue and the issue of what is meant by a swap, rather than try to nullify any of the four required elements of a preliminary injunction, which is, does it serve the public interest? Would there be irreparable harm suffered by Kalshi if an injunction were not entered? And how does the balancing of the equities tilt? Does it tilt in the state's favor, or does it tilt in Kalshi's favor? And I thought that New Jersey left a golden opportunity on the cutting room floor by not dwelling on the procedural posture of the case, because getting a preliminary injunction is an extraordinary remedy. You have to show all four of those factors, and if you can nullify any one of them, the injunction is denied. So what I suspect will happen going forward is that amicus curiae will come in, which are friends of the court, affected stakeholders like commercial casinos, the Casino Association of New Jersey, maybe even Native American tribes. They'll come in, file an amicus curiae brief, and maybe address some of the gaps that were inherent in the New Jersey brief, or at least from New Jersey's vantage point, one would certainly hope. But I think they left a lot on the cutting room floor and devoted too much attention to the definition of a swap, and not enough to the standards on a preliminary injunction, which are central to the whole case.
Yeah, it's going to be fascinating to see how that plays out. I want to switch gears fairly abruptly and get us into Brian Quintenz's hearing, because we finally got to hear from Trump's nominee to lead the CFTC. So I'm going to ask you about Adam Schiff brought up tribal exclusivity issues, particularly surrounding these sports contracts. I want to talk about Brian Quintenz's response to Senator Hyde Smith about what the goal of the CEA and the CFTC is, because that seemed quite broad. I definitely want to talk about Cory Booker's question because he brought up Brian Quintenz's Eris X dissent from 2021, and that was a fascinating and important exchange. And then I want to end with John Boozman's question about why principle-based regulation is so important, because that stuck out to me as well. So let's dive into Adam Schiff's question. He brought up the many tribes in California that have the exclusive rights to offer gaming in that state. What do you make of that line of questioning and Quintenz's response?
Well, Adam Schiff is a California legislator, and obviously he's well positioned to articulate the impact this is going to have on Native American tribes. And it's not just gaming exclusivity that tribes enjoy substantially throughout the state of California, but they have exclusivity over sports gambling on their Native American reservations. And to the extent that these event contracts can be purchased on Indian land and aren't geofenced, these are violating the Indian Gaming Regulatory Act. And they're also potentially violating tribal exclusivity over statewide, gambling. And many of the tribal compacts include exclusivity provisions that don't just simply speak to land-based casino gambling, but also future Class 3 gambling. So compacts are creatures of federal law and state law, and while they are negotiated, signed, and ratified between the tribes and the state governmental entities, ultimately they're enforced under federal law and have to be approved by the United States Department of the Interior. So that gives it sort of the force of federal law. And on the one hand, you have Calshi operating what is in essence sports wagering on a federally regulated DCM that is in conflict with another federal law that speaks directly to the issue. And how do you resolve that? And Brian Quintenz's default position was, well, you got to take it up he said a few things. He said, you got to go take that up with Congress. He's got a very expansive view of what an event contract can include. And his answer is, it can include everything. Everything is a commodity. And therefore, all events are commodities, which means that all contracts on future events are commodities, future contracts, which means that all those contracts need to be traded on a regulated exchange. Okay, that's his interpretation of it, and his retort to Schiff was, you can either take it up with Congress, or you can if you can't beat them, join them and become a DCM yourself. And he extended a gold-plated invitation to the Native American tribes to become registered DCMs on a CFTC regulated marketplace. But what he didn't say was that process takes 1 to 2 years to consummate. You can't become a DCM overnight. There's a very lengthy administrative process that's entailed in becoming a DCM. It's almost akin to getting licensed as a gambling company. You've got to submit detailed applications. There's a thorough review by the agency, a minimum of 180 days. I think that's either statutorily or by rule. So the avenue available to tribes to become a DCM not only ignores the concerns raised by Adam Schiff, but it provides a non-realistic alternative, which leaves the tribes in a situation where they're as disappointed as they were by Caroline Pham's complete inaction and no promises to do anything. I think Brian Quintenz took it a step further and said that this is going to be business as usual. I'm going to allow these event contracts around sporting events to continue unimpeded. I don't even need to make a rule around them. The status quo is probably going to remain in place. So the tribes have a choice. They can either wait 2 years and become a DCM, or they could fight the battle right now in the courts. And I think that's where they may be headed.
So what do you make of, I know Brian Quintenz was asked by one of the senators about what he was going to do about these application timelines. Even if they're substantially shortened or cut in half, let's say they're even 6 months, is that still, does that make a difference for the tribes in trying to launch a DCM? Hard no.
No, because you have to look at the political realities of it. He's a former board member he's a current board member of Kalshi, who owns stock in Kalshi, who was appointed by the President of the United States, whose son is a strategic advisor for Kalshi. I mean, do you really have a high degree of expectation that they're going to expedite, potential competitors' DCM applications? I think the statute gives them a guarantee of 180 days delay. And of course, the CFTC can continually stay the application process if there's any level of incompleteness in the application material. So the tribes are basically having to be on the sidelines for 2 years while Kalshi, Robinhood, and Crypto.com capture the market to the exclusion of everyone else. Because if you try to become a registered DCM today, it's just the time frame associated with it is far too elongated to expect any kind of expedition. I think 6 months is the minimum, but I've been told by numerous experts, and you and I were on a panel with Dave Aaron from Jones Day a couple of weeks ago in Fort Lauderdale. He's a CFTC specialist, and he says the process can take as long as 2 years. The alternative would be to purchase an existing DCM, which is an option, but those DCMs have a going market rate of, at least currently, somewhere in the neighborhood of $50 million, according to some people that I've talked to. So the option to join them isn't really there for the Native American tribes. And they have exclusive rights under their bargain for compacts that allow them the exclusive right to operate sports betting on their own lands, and in some cases, such as in Florida, on a statewide basis without any competition. So is it really fair to ask the tribes to forfeit or move off their exclusivity, for which they're paying the state a significant revenue share, to join a soon-to-be crowded field where they're not going to have any exclusive rights and they're going to be on the sidelines for 2 years? That's not realistic. And I'm not going to make any predictions, but except for one, you better believe that the Native American tribal groups, whether they be individual tribes, coalitions or tribes, or their trade associations like Cienega, any number of groups are going to end up filing court briefs, either as an amici curiae in Third Circuit U.S. Court of Appeals and in federal courts around the country. This issue will ultimately be settled not by Brian Quintenz, but by either Congress or the courts. And the courts are the most immediate point of entry because there are pending legal proceedings right now that present golden opportunities for adversely affected commercial and tribal stakeholders to advocate for a change through their amicus curiae filings. And I would expect the Third Circuit to be a hotbed of amicus curiae filing activity next week from the Casino Association of New Jersey, maybe a few Native American tribes. There will be a lot of friend of the court briefs filed next week because this is where the battle is going to be fought. You know what the CFTC is going to do or not do, but what's not under the control of the CFTC or President Trump are these Article 3 federal judges that have been appointed by Democratic presidents, other Republican presidents. They're free from political interference. And more importantly, there are live controversies before those courts right now. So while the CFTC may delay its roundtable and not do rulemaking, the federal courts in at least 4 different jurisdictions, 3 trial level courts and 1 appeals court, have an ongoing live controversy at which these issues can be resolved with some level of clarity and finality.
Well, let me ask you how Brian Quintenz says he views the CEA's purpose and the purpose of the CFTC. So in response to Senator Hyde-Smith near the end of his answer, he said that, to him, it is clear the purpose of the CEA and the CFTC is to support derivatives markets that provide for hedging, risk management, price discovery, and price dissemination. It's a broad definition, and innovation came up over and over again. What do you make of? What do you think that tells us about Brian Quintenz's likely approach to, not just sports contracts, but event contracts more broadly?
Well, tell me two things. One, on the legislator side, these are like two audience plants that, in between Tommy Tuberville and the other lawmaker you just mentioned from Mississippi, is it Smith? They basically asked leading questions to allow Brian Quintenz to sort of articulate his sort of worldview of how he sees prediction markets and the innovative approach in the absence of any kind of restrictive laws that guide his behavior. He's basically given himself wide berth, sideline to sideline, 100 yards to determine what is and what is not a proper subject of an event contract. And in his view, it all qualifies, all in the name of innovation. So I believe what he's saying is consistent. At the very least, it's consistent with what he said previously with regard to ErisX, what he's told the Federalist Society, what he said in every single public forum. President Trump knew exactly how Brian Quintenz would approach derivatives and event contracts. He's acting consistently with everything he said before, and it's ultimately, I think, going to create a few, either an opportunity, either a showdown right now with the federal courts, or some strategic maneuvering to avoid further judicial review. And what I mean by that is, once the CFTC engages in rulemaking and promulgates rules and final actions, declaring with finality that these event contracts are acceptable and allowable under federal law, those agency actions are going to be challengeable in court. Prior to that point, by doing nothing, not having any enforcement or restrictive actions taken against any of the operators, you're left with something less than a final agency action, and it could largely go unchallengeable, which might be the preferred approach for Brian Quintenz, and particularly in light of the fact that there are not going to be 5 commissioners operating in a full full quorum for a while. And I think the way the CFTC is approaching prediction markets right now will probably be the same approach, laissez-faire approach, taken on a going forward basis, because the moment you invoke the Administrative Procedure Act by passing formal rules, then you're going to be hit at from so many different angles, states, tribes. It opens the floodgates for lawsuit challenges, even going beyond the ones that are existing now.
Mm-hmm. What is the bar for? I know we didn't plan to talk about this, but what is the bar for issuing a challenge based on the APA?
I would say promulgating a rule, a regulation, which is a final published rule that triggers a right of action, potential right of action under the Administrative Procedure Act, but is inaction, subject to challenge under the APA? I don't think so. That would instead be addressed through mandamus type actions, and I don't know that mandamus would be appropriate here unless it's a mandamus action initiated by a registered exchange or by someone within the CFTC. It might be difficult for states and other non-CFTC affiliated entities to pursue a mandamus relief in the federal courts against the CFTC if there's no sort of relationship there, or no fiduciary duties or duties owed to those individuals. We're in uncharted territory on a number of things here. This whole thing is uncharted territory, but the mandamus route might be the only thing that could be available short of final agency action. And it seems to me that there's not a lot of incentive for the CFTC to formalize anything that would then make their policy vulnerable in federal court. Right now is the best place they can be. Actually, the best place they can be is have Congress, under the Trump administration, amend the Commodity Exchange Act to make crystal clear that swaps under the exclusive jurisdiction of the CFTC can include sporting events, maybe even casino contracts, and whatever, because there's a limited runway here in which Donald Trump is going to be president. Assuming he doesn't upend the Constitution and run for a third term, his term is going to end on January 20th, 2029. And if the CFTC does nothing, takes no action, there's a decent likelihood that this existing regime that lasted for the duration of the Trump administration could go away with the snap of a finger if there's a different policy priority. So it may be incumbent, well, I wouldn't say incumbent, but I could see a way of cementing or clarifying the legal validity of these event contracts by having a Republican-controlled Congress acting at the whim of President Trump, making some subtle adjustments to the Commodity Exchange Act so that it puts any rule challenges completely out of reach. And I think that is certainly one possibility.
That would be a fascinating turn of events if Congress got involved so directly. But I do want to go back.
It's not regulating sports betting. It's just simply doing as little as possible to sort of close up the void in the CEA, which has basically threadbare authorization of anything relating to gambling. And if anything, indications that gambling event contracts are probably contrary to the public interest based on the legislative history. So a Republican-controlled Congress can turn that upside down. So the advantage to doing nothing is you avoid the rule challenge. But the disadvantage of doing nothing is that you leave a clean slate for the next presidential administration to upend everything that took place under Quintenz's watch in the Trump administration. So I could very easily see a scenario in which Congress, clarifies or provides the kind of support that the agency needs to put this issue free from any future challenges.
Yeah, that'll be fascinating to see how they use their time in office. But I want to go back to something you brought up earlier, and it's something that Cory Booker brought up as well. He read directly from Brian Quintenz's 2021 dissent, defending another prediction market platform, ErisX, defending their right to offer a certain set of NFL contracts. And Brian Quintenz quoted the statutory definition of a commodity, which, and I quote, includes an occurrence, extent of an occurrence, or contingency that is, one, beyond the control of the relevant parties to the contract, and two, associated with financial, commercial, or economic consequence, which in his defense does seem to encompass every event that you can imagine. So I know Cory Booker and Brian Quintenz had this exchange where, Quintenz claimed that Booker had read over some or excluded some part where Quintenz stipulated that it was just across state lines that he objected to these contracts. It was an odd little moment that I didn't find in the ErisX dissent. I don't know if you caught that or if you had any thoughts on that.
Is he raising the Wire Act that the sports bets?
So, yeah.
Yeah, the sports bets that are licensed under state law become violations of federal law if they are transmitted through interstate commerce across state lines or what have you. Whereas if you're going to really be a proponent of the Wire Act, you could also take the position that buying and selling these contracts between traders located in different states raises the same or triggers the same Wire Act problem, regardless of the terminology. And you run into the problem of how Kalshi has characterized its event contracts and some of their social media promotions. It's legal sports betting in 50 states. I think that was the quote that Senator Booker used in his question. And when you have a designated contract market referring to these event contracts as bets or wagers, and their traders are located in different states and they don't do any geofencing, how is that indistinguishable from the type of cross-border sports betting that Quintenz suggests might violate the Wire Act? So it was an interesting analogy, and I'm not sure he understood or appreciated the implications of that.
Yeah, well, let me ask you, he also brought up, especially in this post-Loper-Bright world, the CFTC would have to, rigorously defend any public rule that it made. He wrote his ErisX dissent, years before Loper-Bright. Could you tell us, first of all, what the Loper-Bright case is and what you make of Brian Quintenz invoking it now in a Senate hearing?
Well, I mean, Loper-Bright, if anything, stands for the proposition that since that decision, which eliminated the Chevron doctrine, which required courts to defer to administrative agency interpretations of ambiguous statutes.
Right.
That post Loper Bright, courts no longer have to give that kind of deference to agency interpretations. So I don't know that Loper Bright helps the CFTC or helps Brian Quintenz have this unfettered discretion to interpret the Commodity Exchange Act any way he sees fit, because you have to admit the definition of swap is ambiguous. It could mean any number of different things. Taken literally, it could encompass macro events like presidential or congressional control contracts, sporting events, whether a passenger is going to miss his train or not. So taken to an extreme, it covers everything. And I would submit that standard is pliable. It's somewhat ambiguous, and you would want to look to congressional intent. And in an ambiguous situation, pre-Loper Bright, the agency would have the deference afforded to them by the courts to interpret ambiguous statutes based on their expertise. Well, that deference is gone post-Loper Bright, but I don't know if Loper Bright is applicable to situations where the agency isn't taking a final action that's governed by the Administrative Procedure Act. Loper Bright occurred in the context of an APA challenge to final agency action. So does Loper Bright apply outside of the APA? There are some courts that have said it does not. So I think Loper Bright would be more forceful if there were a situation where the CFTC promulgated a new final rule, maybe changing Rule 40.11 to remove the prohibition against gaming contracts and make that more discretionary and have a real two-part test instead of the blanket prohibition. Until that happens, I don't think we're in an APA posture if the agency does nothing and it's just simply inaction. But I think the line of demarcation for Loper Bright being definitely applicable is when the agency engages in some kind of formal action where it's not current and it's not currently in that posture yet.
Right.
So but the theme of Loper Bright is that courts are going to make the final call, not agencies. And while Brian Quintenz may operate a fiefdom, at least in his view in the CFT, what he says goes, his word will not be the final word. Trust me on this. The courts will decide what the CEA means. We'll decide what swaps means. We'll decide whether the CEA's grant of exclusive jurisdiction usurps state authority over these kinds of contracts. All those questions will be decided in federal courts with finality. But for now, for the duration of the remaining 3.5 years that Donald Trump is going to be in office, if not longer, with Brian Quintenz as chairman, that's going to be the law of the CFTC. There's no question about it.
Yeah, let me end with asking you about the last question he was asked. John Boozman, the Senate committee chairman, he asked Quintenz to explain why principles-based regulation was so important for fostering innovation. What do you make of the Republican senators' emphasis on innovation and the principles-based regulation as opposed to stricter rule-based regulation?
Well, I mean, principle-based regulation is basically no guardrails, no restrictions, no limitations. Basically, as long as anything you're proposing is consistent with the sort of overall philosophy, it's legal, which doesn't have a line. There's no measuring stick to determine, well, is this legal or not legal? You're leaving too much subjectivity to the individual commissioners to determine whether a particular course of action is consistent with this overriding principle. You need to have, with contracts involving gambling, sports betting, prediction markets, it's helpful for the parties to know what's permissible, what's not permissible, and to have that set out in a statute, not at the whim of a regulator, because regulatory bodies change with every change of administration. And just like we saw with the Department of Justice with respect to the Wire Act, the Obama interpretation of the Wire Act as only being limited to sporting events gave way to the Trump administration's view of the Wire Act as applying to all forms of gambling. You need to have consistency, uniformity, and predictability around the law, and a principles-based system as opposed to a rules-based system removes that predictability and makes it subject to, whoever is king for the day.
Mhm. Yeah. Do you think, I know some of Brian Quintenz's concerns about, some of the ambiguity in the CEA, for example, include, defining the public interest. Do you think?
Now, I'm sorry, you just got me off on that, because
Well, let's go.
Brian Quintenz isn't a lawyer. He's basically saying, and what he's advocated in his dissenting statement in RSX, is that the special rule granting the CFTC the discretion to reject contracts to reject contracts as contrary to the public interest, if they touch on any of those enumerated categories, that affords guidance-less discretion to a federal agency in violation of the non-delegation doctrine, which is a sort of a constitutional principle which forbids Congress from delegating its legislative power to another branch. He's been on that kick for the last 4 years, and he's dead wrong. There are a number of statutes federal statutes that have required federal agencies to make determinations as being in the public interest. And there's a Supreme Court decision on point, NBC, National Broadcast Company versus United States, 1943 decision that upheld a delegation to regulate in the public interest. So Brian hasn't done his homework on the case law, and he's not enforcing Rule 40.11A1, which is the blanket ban against event contracts involving gaming, because he believes that grant of discretion to the CFTC violates the non-delegation doctrine that has only been utilized or invoked 2 times in our nation's history, a total of 2 times, the last time being in 1935, 90 years ago. So you can never say never, but I think incoming Chairman Quintenz's interpretation of the law misses the mark, and the grant of granting the authority to the agency to conduct a public interest review on a case-by-case basis, or in toto all at once, which is what happened in 2011, is perfectly acceptable under United States Supreme Court decisional law.
Well, what's interesting too is for his professed concern about overstepping his regulatory authority or overstepping Congress's intent. I mean, choosing not to, just take one example, choosing not to conduct a public interest review is still a monumental decision, and it's still within his discretion to do. I mean, he's still making very significant choices.
It's somewhat selective. I don't mean to rail against incoming Chairman Quintenz, but he's very selective as to when people should go to Congress. The tribes and the online sports betting companies have to take their issue up with Congress, but when there's no affirmative authorization for these kinds of event contracts, I mean, I think he picks and chooses, but it's a great deal of selectivity that Chairman Quintenz is engaging in, and I believe the special rule is constitutionally proper. And the rule that the CFTC unanimously passed in 2011 is valid. He just chooses not to recognize it. And I think while the agency isn't going to enforce that rule, I think the federal courts could look at that inaction or non-enforcement as a factor to consider in resolving some of these motions for preliminary injunctions. So far, it hasn't come up as a major issue, but the longer this rule remains on the books and not withdrawn, not amended, not supplemented, there's a possibility that the CFTC's inaction could end up being a factor that leads to Calshi losing a case here and there. So the CFTC should do something. Instead of believing that the delegation is unconstitutional, if it believes that the blanket prohibition is not the correct way to go as a policy matter in view of the fact that now sports betting is legal, in 38 out of 50 states, I think the CFTC should engage in rulemaking to change that.
Yeah, it'll be fascinating to see how the courts resolve these issues, but we have to leave it there. Thank you.
All roads lead to the courts, which was going to make for some fascinating podcast down the road. I mean, in looking at the prediction markets, in the short term and the near term, they should be good to go for at least 3.5 years. But ultimately, the final battles, the last word is going to belong to the courts or Congress if Congress steps in and does this administration's bidding to eliminate any of the legal doubt surrounding the current course of action.
Yeah, well, I know we'll both be watching the courts very closely. Those of you watching, thanks so much for joining us at Prediction News Update. Like, comment, subscribe to our channel. Check out our news reporting at predictionnews.com. And Dan Wallach, thanks again for joining us.
My pleasure. Thanks for having me back, Chris. Talk to you again soon.
We'll see you. Thank you.